This is an introduction to regulatory drafting in California. What exactly is regulatory drafting? Well, regulatory drafting or drafting regulations is the work done by state executive branch officials in the 200 plus agencies, departments, boards, commissions, and bureaus that have rulemaking authority under California's Administrative Procedure Act, the APA, found in California's Government Code. Of course, regulations can also be drafted by attorneys, lobbyists, interest groups, and others who want to propose the addition, amendment, or repeal of regulations that are contained in California's Code of Regulations. As opposed to legislative drafting of bills, resolutions, and constitutional amendments that are considered by the legislature, regulatory drafting concerns the quasi-legislative lawmaking that's done by the executive branch of government in the state of California. Again, there are more than 200 of these state entities that have the authority to adopt regulations. Despite the different venue, executive branch versus legislative branch, and the different form of lawmaking, regulations versus bills, regulatory and legislative drafting are quite similar in nature. The main goals for each: clarity, consistency, the use of plain language in drafting. Following the rules of proper grammar are similarly critical in both forms of drafting. In some jurisdictions, the drafting of what is often referred to as secondary legislation includes regulations, notices, executive orders, and similar documents that are done by non-legislative drafting professionals in many instances. And in California, like at the federal level, there are professional bill drafters for the legislature, about 85 attorneys who work for the Office of Legislative Counsel. Although the legislature has considered establishing an Office of Regulatory Counsel, it has not formed one as such. So there is no consolidation of the drafting of regulations among those 200 plus executive branch rulemaking entities. Someday that office may come to fruition. Again, in multiple jurisdictions, these types of offices exist within the executive branch to oversee the drafting of secondary legislation. Professional regulatory drafters utilize skills they have developed through drafting measures, primarily through on-the-job experience and training. Unlike other forms of writing, poetry, fiction, regulation drafters must select their words carefully to avoid unnecessary prose, as well as to write in simple, consistent formats to reduce ambiguity and confusion for the reader. Drafters of regulations will thoroughly research and understand the authorizing statute and what needs to be put forth in a regulation to implement, interpret, or make specific the statute that the executive branch entity is charged with administering. It's important when drafting regulations to do so in conformity with the Administrative Procedure Act requirements, the APA. In addition, drafting clear and concise regulations will, of course, assist the regulated community and the entities that enforce the statute and regulations, and naturally, the judicial branch, our courts. These should also be consistency among the regulatory language used, particularly those within a specific executive branch entity. Moreover, drafting norms such as gender neutral language and plain English should be followed as well. Keep in mind that plain language does not always work in regulations. For example, when drafting a regulation of a very technical or scientific nature, the plain language concept may not be able to be followed in every instance. Instead, the regulatory language will have to reflect the technical nature of the substance of the proposed law. For someone experienced in drafting legislation, many of the rules and guidelines in regulatory drafting will be familiar. For those who work exclusively with the executive branch and engage in rulemaking activities, learning the key concepts and drafting principles used in legislative drafting can be immensely helpful in drafting those regulations in the executive branch of California state government.